This is absolutely insane what is going on today. So, where this video begins is the beginning of the live stream that is currently still live. And seems like the judge is mid-sentence, like speaking as the video cuts in, and what he seems to be saying is something about because just the fact that he's sitting next to someone doesn't incriminate him. So that's where it begins. This is probably going to be about 5 or 10 minutes long for this hearing, maybe 15. I don't even know the end yet, but I wanted to capture this. Give it a second.
Incriminate him, or not has not subjected him to criminal liability, at least yet. So
And
you're saying beyond that
that's the key word, Judge, is yet.
Yeah.
Is yet. The question
You think his observations of how George Floyd looked would incriminate him?
Absolutely.
I don't see how that would put him closer to criminal liability just with those observations.
Because it then takes the onus off of the state in any future prosecutions to prove what demeanors, behaviors, attitudes Mr. Floyd was exhibiting should they decide to charge Mr. Hall with the crime. Now they've got his own testimony to use against him. That's the very definition of a Fifth Amendment privilege, Judge.
Well, if it incriminates.
Yes.
Just the fact that he testifies does not make it incriminating.
But his testimony would be used to incriminate him in a future prosecution.
Anyway, Mr. Frank, do you need to weigh in on this? I don't think you have a dog in the fight at this point.
Well, I do, Your Honor. I would like to be heard briefly.
Sure.
Thank you, Your Honor.
You're not going to represent his interests, are you?
I am not.
Okay,
Our dog in the fight is a fair trial for Mr. Chauvin,
of course.
and one trial. And what we can't have is an invocation of this privilege in front of the jury. And this questioning that the court is offering or suggesting creates a huge problem. And the reason why I cited the Caldwell case to the court is because this questioning would not exist in a vacuum. And we have to remember, too, that the standard is not just whether this evidence itself is inculpatory or implicates him, it's whether it creates a link. And I think that's partly what Ms. Cousins is referring to, is it now puts him in that vehicle, and it's testimony from he himself creating the part of that link. And as I said, it won't exist in a vacuum. There would be other questioning, and we would have the right to question him about his credibility and other aspects of that interaction then that would lead, unfortunately and potentially, to him invoking question by question in front of the jury.
But we regularly, in fact, did in this case, in excruciating detail, walk through motions in limine, limiting what questions could be asked of various witnesses based on rules of evidence. This is not based on rules of evidence, it's based on his Fifth Amendment rights and what could possibly incriminate him. But limitations, and you gotta admit, as Mr. Isaacman and I can tell you, the Caldwell case is a totally different situation. That was a man who wanted to testify despite being warned that everything he said would incriminate himself, and didn't care until he realized it might get him into more trouble than he thought. I think it's the complete opposite of this case.
It's an illustration, Your Honor, of how, despite that witness trying to tailor his evidence to meet a certain goal, it just couldn't be done. And it led to, and unfortunately in that case there wasn't a jury sitting there, but that invocation, that's where they ended up in that case. We can't have that when we're in front of a jury. And Mr. Hall would be faced with the question by question determination of what we're arguing about this morning. That's why sort of a blanket invocation is allowed because the standard is rather broad.
What case law says that there is such a thing as a blanket invocation of Fifth Amendment rights?
I can't cite the court a case that has yet.
Well, and I'll admit,
blanket invocation, but
and I'll admit, I don't think there's clear Minnesota case law on it, but I'm looking at Illinois, the Northern District of Illinois, Oregon, I think Hawaii as well. A couple of cases, just take a look at Hillman versus City of Chicago, 918 F sub 2nd 775, which is the Northern District of Illinois. Oregon versus Rodriguez, 301 Oregon Appellate 404. Shackman, Shakman versus Democratic Organization of Cook County, which is 920 F sub 2nd 881. It's pretty clear from those cases, and granted they are not Minnesota, that the invocation of the Fifth Amendment right is on a question-by-question basis, and the legitimacy of that invocation is to be determined by the court, which makes sense. Otherwise, somebody who just didn't want to testify could say, I'm asserting my Fifth Amendment rights.
I agree with that concept, Your Honor. We cited the court case where they talked about a voir dire process. And essentially, this hearing is a substitute for that process because we know from his counsel that he is going to invoke the Fifth Amendment about the very areas she discussed. And there just is no legitimate way. I mean, there isn't really any question that all of the matters that counsel identified and Mr. Nelson identified are tied intimately to his interactions with Mr. Floyd that day and in the previous weeks, and it ties him. So we're not facing a question like maybe perhaps in those cases where they might just be invoking because they don't want to testify. Here there is a legitimate link in the chain from what he's going to be asked about and quite a few potential crimes, not just the third-degree murder, obviously being the most important. I mean, we even know, we've talked about the sense of opposing counsel has suggested almost an alternative perpetrator in that sense, with the third-degree murder, but there's also drug charges, counterfeiting, false information. And I don't know how we put on Mr. Hall to testify and ask him one question and then let him leave without having the ability to pursue, as we normally would in a trial, the credibility and the foundation for that testimony in light of all we know. So I think that this case doesn't raise the kinds of questions that maybe are being brought up in the cases the court cited. I'm sorry, I can't speak to them personally right now, but here there's no question that the singular questions the court is inquiring about are intimately linked to George Floyd and the activities of that day, all the other areas that
Well, I think if you look at the case law, it's much closer to incriminating behavior like the Shackman case. It's really clear that I would have not ruled the way they did. I would have said that was a proper invocation. And they're like, no, that's not a problem.
well, that's Illinois.
Yeah, let's do this step by step. I appreciate your argument, and I think I know where we're kind of heading with that. This is what I'm going to propose. We're not done today with this. I think we have pretty much established, or based on what Mr. Nelson has said, there's really a very small, narrow topic that might be permissible. So what I'm going to do is I'm going to ask Mr. Nelson essentially to draft in written question form with the expected answer based on whatever statements were made on what that would be. That way, Mr. Hall can meet with his lawyers and talk about would he be willing to answer those. Then we can have another hearing outside the hearing of the jury.
That's the guy.
We'll walk through and see if he would. Number one, if I, based on my review of the examination, believe that it is a proper invocation of Fifth Amendment rights to that or not, question by question basis. And if I say it's not a proper invocation, is Mr. Hall willing to answer? Despite your ruling, Judge, he's still not going to. Well, he is subject to contempt then. But I think we get too far ahead when we kind of are being vague. Let's say, what are the questions we're going to ask him? Let's walk through outside the hearing of the jury whether or not I would allow it and find that it's not incriminating. And then based on that, Mr. Hall can meet with his lawyers. So I'm talking by Thursday. I'd like that list. The state can do any indication of cross. Same thing. I'm guessing what you would want to cross Mr. Hall on as far as his credibility and all that, well, it's pretty much up to you, Mr. Frank, but I think that might, since it might widen the net some, so to speak, some of yours might clearly get him into Fifth Amendment issues. But I think we need to, if Mr. Nelson can get you that, you can write write up your own list of questions. Let's do it outside the hearing of the jury. And he has time to talk to his attorneys before we put him on the stand cold, and he has to confer with them one by one. So, and it's a limited, I'm only allowed for that limited, and this isn't a final ruling. This is the only part that I think is possibly not subject to a Fifth Amendment claim. Tell me what you want to ask. We'll run it by outside the hearing of the jury on a question by question basis. The court will make a determination, and then counsel can follow up with Mr. Hall, and based on the court's ruling, are you going to testify? And we go from there. So I don't want this to be the last and try and push through a ruling when we need to tread carefully. Obviously, Fifth Amendment right is a broad one, and I agree. The link, you have to worry about links to possible prosecution, but at the same time, if everything's linked, then it's a blanket prohibition, and that is not the case law. So with that, everybody's got their homework assignments. Let's go with that. All right.
Very well. Thank you.
But for now, do not waste your time on all the other stuff. It's that narrow, limited area that we're going to talk about. Okay? It's 5 to 9. Let's see. We'll probably start up at 9:15 with the jury. All right. We're in recess. Thank you, Mr. Hall.
Thank you, Judge.
What they just talked about coming up with a narrow line of questioning is so that the defense can effectively and appropriately use this witness to exonerate their client, the defendant. The state has now acknowledged with the judge in hearing that any other line of questioning besides that will lead to a question-by-question invocation of the Fifth Amendment, because the circumstances in question would cause future prosecution of that witness, possibly for up to and including all of the charges that somebody responsible with the death of George Floyd would have placed on them. So, that's an enormous bombshell. That is huge. And I'll bet the media is not going to talk about it. The news is not going to get into it. And you're going to have a whole bunch of people throwing drama and getting into the divide and conquer back and forth, the seduction of drama, as it were, about whether or not the drugs matter, whether or not what and this and no. See, we saw the video, and it's like, no. They've seen the video too. And now they've got witnesses that are going to have to testify that are going to end up self-incriminating, which means that the liability, the culpability for the wrongful death falls on someone other than the defendant in this case. That is what this is leading to. If it isn't a mistrial, it's got to be an acquittal at this point. At the worst, they might try and still keep pushing the third-degree manslaughter because of just the fact that the defendant was involved in the incident at all, like he was present. If he was the one in charge of the scene and they find that he was not correct in his knee hold, then he may have some accountability. However, the cause of death has nothing to do with the actions of that defendant from the look of it. But the question is, will the masses of people who only get their information third or fourth hand, either through what somebody else tells them, or, even this is secondhand, I showed you the thing, but I'm explaining it just in case you don't understand. Will the people that don't understand, don't want to understand, be able to cope with the reality of what this means? Or will we have riots when this case does not end in this dude getting convicted of murder? Can they handle the truth? That is the question.